and welcome to another episode of Supreme Court Judgments of the Week on Verdictum. In this segment, we bring to you the most interesting judgments passed by the Supreme Court during the previous week. Let's begin. Ranjan Kumar Chaddha versus State of Himachal Pradesh. A Supreme Court bench of Justice M.M. Sundaresh and Justice J.B. Pardiwala summarized the principles prescribing the conditions under which a search of persons must be conducted, as laid down under Section 50 of the Narcotic Drugs and Psychotropic Substances Act. In the present case, the petitioner, Ranjan Kumar Chaddha, was searched for charas after the police received secret information of the same. According to the information, Chaddha was in possession of contraband in form of charas. He was searched by the police physically, and his carry bag was also searched, in which charas was found. Chaddha was acquitted by the trial court, stating that the prosecution could not prove its case beyond reasonable doubt. An appeal was filed by the state in the High Court, which convicted him under Section 20 of the NDPS Act, which lays out the punishment for production, manufacture, sale, purchase, import, and interstate export of drugs. The top court considered the question as to what meaning should be assigned to the phrase "to search any person" occurring in Section 50 of the NDPS Act, and whether it would include the search of articles in immediate possession of the person. The court held that the main object of Section 50 of NDPS Act is to avoid the allegation of planting or fabricating evidence by the prosecution or the authorized officer. The top court further said that the term "to search any person" would mean only search of the body or wearing apparels of such person. It reiterated that conditions for personal search under the statute are applicable only to the search of the physical body of a person and do not extend for the search of any bag that person is carrying. State Bank of India and others versus P. Zadenga. A two-judge bench of the Supreme Court comprising Justice Rishikesh Roy and Justice Sanjay Karol reiterated that criminal proceedings and departmental proceedings are separate and distinct, and there shall be no effect of one on the other. The respondent in the case, P. Zadenga, was employed with the State Bank of India as Assistant CAT. However, disciplinary proceedings were initiated against him after 3 government retailers lodged complaints against him, claiming that their challan deposits were not being deposited in the branch. The district civil supply officer also complained regarding a retailer using fake challans to obtain a specific food delivery. 3 FIRs were filed against Zadenga, and he was arrested, but was eventually released on bail. As a result, Zadenga was dismissed from the service by the disciplinary authority. Zadenga filed an appeal, which was rejected. He then filed a second appeal before the Guwahati High Court single judge, which was allowed. The bank filed an appeal before the division bench of the High Court, but the order passed by the single judge bench was upheld. The same resulted in the suspension of disciplinary proceedings. Aggrieved by the order of the High Court, the bank approached the Apex Court by way of a civil appeal. The Supreme Court was faced with the question whether acquittal in connected proceedings will entail a benefit to the delinquent employee, leading to an automatic discharge in disciplinary proceedings. The Supreme Court relied on many previous judgments passed by it and held that the nature of proceedings being wholly separate and distinct, acquittal in criminal proceedings does not entitle the delinquent employee for any benefit in the latter or automatic discharge in departmental proceedings. Pankaj Bansal versus Union of India and others. A two-judge bench of the Supreme Court comprising Justice A.S. Bopanna and Justice Sanjay Kumar dealt with a batch of appeals challenging the orders passed by the Punjab and Haryana High Court. In its order, the division bench of the High Court observed that despite the fact that the Supreme Court has affirmed the constitutional validity of Section 19 of the Prevention of Money Laundering Act, the challenge to the said section by writ petitioners could not be taken into consideration only because a review petition was still pending before the top court. The High Court's division bench further held that keeping in view the gravity of the allegations against the petitioners, their prayer to be released from the custody did not deserve acceptance and rejected the same. What gave rise to the present appeals was an FIR filed by the Anti-Corruption Bureau in Panchkula, Haryana, under Sections 7, 8, 11 and 13 of the Prevention of Corruption Act of 1988, read with Section 120B of the Indian Penal Code, for the offences of corruption and bribery, as well as criminal conspiracy. Significantly, prior to this FIR between years 2018 to 2020, allottees of two residential projects developed by the IREO group filed 13 FIRs alleging wrongdoing on the part of its management. Basing its case on these FIRs, the Enforcement Directorate filed an Enforcement Case Information Report in relation to alleged money laundering committed by the IREO group, its vice chairman and managing director. After connecting the dots of alleged money laundering by the IREO group, the Enforcement Directorate launched raids targeting the M3M promoters and others. Notably, neither in the FIRs nor in the first ECIR were M3M group or the appellants, namely Pankaj and Basant Bansal, were arraigned as the accused. Furthermore, they were not subject to any accusations against them. ED filed a prosecution complaint against 7 suspects, and according to this particular complaint, the number of FIRs was 30 instead of 13. The ED then conducted raids on properties of M3M group and confiscated assets and bank accounts. The accused were also detained, which is what led to the present case being presented before the Apex Court. The Apex Court observed that the remand order passed by the learned judge of the Sessions Court in Panchkula reflects total failure on his part in discharging his duty according to the expected standards. The Enforcement Directorate was also criticized by the Supreme Court, which said that ED, being a premier investigating agency charged with the onerous responsibility of curbing economic offences of money laundering in a country, every action of the ED is expected to be transparent and conforming to pristine standards of fair play in action. The top court further said that ED is not expected to be vindictive in its conduct, and the facts demonstrate that ED failed to discharge its functions and exercise its power as per these parameters. In the case at hand, ED's investigating officer merely read out the grounds of arrest to the appellants, and this form of communication fails the mandate of Article 22, Clause 1 of the Constitution and Section 19, Subsection 1 of the PMLA. The top court said while setting aside the orders passed by the High Court. With that, I, Ananya Singh, thank you for watching Verdictum. For more such informative content, don't forget to subscribe to our channel and download the Verdictum app on iOS and Android for latest legal updates.